Hello, everybody. Hello, Jerry Matthew Boyd. Hello, Nana Laura. Hello, Iron Mother, my faithful liker. Oh, there's the Ava. Right on cue. Oh, hey, that worked out pretty swell. Actually, I got two pieces that were separated by some other pieces, but I actually think, yes, they do go together. It's a perfect match, like me and Ava. Hello, Penny. I haven't seen you for a minute. How are you, sweetie? Oh, I know. Full SSRI eyes and all. She's a little bit entitled. People know I go live at this time. Yes, Mortimer Duke, I am on. What a goofball. I love him. Oh, I had quite a bit of that today. I had a very rare, unusual circumstance today where I actually had to choose which cases I was going to put on because there were so many to choose from. I couldn't believe what a day it was. Yeah. I'm pretty sure I'm the only one that got this wild gal because it only said that one was watching, and that was me. It looks like that, doesn't it? Yeah. It's like she's wearing, I don't know, something lacy on top. I don't know where anybody gets an idea like that from, but I'm not in court. That's all right. More will show up later. You guys know I'm here for you. I'm here for everybody that comes and wants to be a part of the gang. And honestly, we just try to make it entertaining for the replay crew. Hello, Charlie. They did an excellent job on that transition. Hello, Eileen and Carlin. I don't know why. I did. I can prove it too. Because StreamYard now marks off which ones I've clicked and which ones I haven't. Yeah, that's super helpful. Hello, Jerry Matthew Boyd. I know the problem's not advertisements because I know you have ad blockers. So I don't know what it is, but you were, I think, the first person I said it to. Pretty sure it was on your hey loves comment. So I don't know what to tell you. Hello, Linda Adams, honey. I just started. So, I mean, it's only been 5 minutes. Hello, Dark Zoomy. I mean, YouTube seems to be operating on April time tonight. I can hack that. Oh, tell me about it. I'm right there with you. Yeah, we can be insomniac buddies. Hello, Purple Kiv. Oh, well, if you can't sleep, you know where to find us. Hello, Mortimer Duke. I have a where my people I hate calling it that, but it's a social worker. But it's just a social worker for like they set up so that I have the services of people like coming in to help me do laundry and someone to shovel my snow and plow my driveway, and then they have someone come and mow my yard in the summertime. So it's a social worker, but not that kind of social worker. It's a different kind of social worker. She and the nurse will be here tomorrow. I will put the okay. Apparently I'm getting told it's treat time. Let me put the cat cam up. There we go. Oh, no. There we go. All right, I'm coming. Oh my, you are so cute. All right. Billy's outside. Tiny Kitten's in her box. So I got Earl, and Snitch will appear. Oh, Ava, you've learned to check the floor for treats now, haven't you? Hi, Earl. I love your meow, Earl. Hi, Snitch. Ooh. Those all went behind the door. Ava will be after those. I should check that basket and see if they're actually even getting anything out of the basket. Because they don't like the basket. But I throw treats in it to try to entice them into it. Oh yeah, they've been clearing it. Hi, Tiny Kitten. You don't want to come up here, do ya? No? Some up here for Billy. Oh, Ava, you are so hilarious. Hi, Tiny Kitten. Oh, my tiny baby girl. Oh, my tiny girl. There you go, sweet love. I'll probably be hearing Billy out the window very soon. Because he loves that sound. Hello, Ice Rose. Thank you so much. I hope you can stay for the cases. Hello, Buzzy Pug. How's my sweet sis? You give me every time. I love you so much. All right, guys. Yeah, we've got some good stuff, and it wasn't even all I could have done. So, but it's already like 2 hours and 15 minutes. So, yeah, there's lots. There's lots. Why? You got to see my booty just as much as he got to see my booty. And it's really not that impressive. He just knows that it makes me laugh. Oh, what did I name it today? There it is.
Can you unmute, please? Ms. Simmons, can you hear me?
Yes, ma'am, I can.
Okay.
Okay, there we go.
Okay. The reason you are here today is because you owe a balance of $215 on your case because you didn't successfully complete your driving safety course dismissal. When can you pay that $215?
So I believe that there was a miscommunication because I did complete that and I sent in a driving record. I guess I wasn't aware. Y'all did send me something back on the 9th. I had sent y'all the email with everything in it on the 6th of February. And y'all had sent me back that it was the wrong driving record and I never received that email. And I did get it, but I never opened it, I suppose.
So I do show that you were granted a 2-week extension on January the 20th. And just 1 second, let me.
February 6th. Okay, yeah, no problem.
Yeah, on February 9th, we received the driving safety course certificate and the driving record, but the driving record was missing the stamp and signature.
Right. And I guess I got confused with that because I thought I had selected the right one. I know there's a few different options. I've never done it before. So I guess I had gotten confused and just thought I was good. And I had never opened or saw that email y'all had sent me saying it wasn't. And then I had received the letter saying it was the second attempt and I didn't ever receive anything in the mail. And the lady on the phone Friday said that I received something in December, but I had taken care of everything in February. So I wasn't sure why. I was just kind of confused.
Well, I mean, let's see, just 1 second.
Yeah, of course.
Yeah, the paperwork that you receive when you sign up for the driving safety course dismissal is very specific about what you need to do in order to successfully complete that. And it's very specific about the driving record that needs to be obtained. And I show that we sent you an email on the 9th. And so it looks like a judgment was entered after we didn't receive the accurate driving record, the correct driving record.
And can you tell me exactly when that judgment was made? Was it made like on the 9th or,
let me check. Just 1 second.
How long did y'all give me?
Just 1 second.
Yeah, no problem.
Looks like March the 17th is when that order was entered.
And y'all never sent me like an official notice. It was just the email back was all I ever.
I'm sorry, the official notice of what?
Because shouldn't I have received like a notice in the mail saying that?
We did. Well, we sent you.
It was a mistake.
Just a minute. We communicated with you by email, and you told me you didn't open the email, saying
Correct.
that
I did not see the email. I went back after Friday after I had called y'all to figure out what was going on, and they said that they had tried to contact me. So I personally went back into my emails and saw that yes, y'all did send me an email. I emailed y'all on the 6th, and y'all emailed me back on the 9th. I do have that in my records. And so I just never saw until Friday when I looked back, hey, they did send me an email,
Okay,
you know? So I was not aware.
okay, but
So I'm confused how I was
stop
convicted
talking
when
when I'm talking. When we send you an email that tells you what's missing, we expect you to read the emails. You're the one that is affected by that. You admitted that you received that email, you just didn't open it.
that I was
So
not aware of it. Okay, let
how
me know when I'm
you're
allowed
the
to
only,
finish.
just a second, you're the only one that can be aware of emails that you receive. Okay?
Correct. Okay.
So
Yes,
the
ma'am.
fact that you did not open an email that we sent to you is your fault, not ours.
Okay,
Okay?
gotcha. Am I
So then
talk now or?
so you owe $215. So how are you going to pay that?
Okay. Is there any way that I can get an extended court date to talk to somebody and hire an attorney? Because this is absolutely ridiculous. I don't deserve to be treated like this over being confused over an email that I was unaware of until Friday when I looked back and saw the email. I understand that that is my fault, but I was taking care of everything up until this point. It was a miscommunication between us. Now I spent like $400 on self-defense and paying on to do all the stuff to take it off my record.
No, ma'am. It wasn't a miscommunication between the two of y'all. You were the only one confused.
And over a mistake, y'all are going to falsely convict me when I tried to take care of all of it. That doesn't make any sense.
It's not a mistake when all the paperwork indicates what type of driving record you were to submit. You didn't submit the correct one. We gave you an opportunity to submit the correct one. We gave you over.
When did you?
We gave
So
you
an email
on February the 9th. We gave you that notification. You had 6 weeks to take care of it before the judgment was entered. Okay.
And so the letter that I got last week was a second notice. When did y'all send me the first? I'm confused. Like that doesn't make sense to me. I'll pay the $215. That's fine, but I am going to go talk to an attorney about this. So how do I pay it? I'd like to pay it for cards.
On May 11th.
Yes, please go talk to an attorney so you can have even one more person tell you that you're the problem.
There was a notification sent to you.
Okay, didn't receive that. So there's no record of mine that I have that on there. I will pay the $215 today, but I am going to contact an attorney. So I'd like to pay it by credit card, please.
Okay. You'll see a notification on your screen to join another room. Join that room and they will tell you how to make your payment. Okay.
Perfect.
Our next file is going to be People to State versus Max Allen. The file number is 26-14224 FH. Here's please.
For the people.
I'm Jeff Harrison. I'm here on behalf of Max.
Thank you.
He's coming into the courtroom right now.
All right, Mr. Allen is being escorted currently in pretrial custody. Also here this morning is Mr. Kevin Stapleton, standing in for Ms. Lindsay Simmons from the Department of Corrections, who prepared today's pre-sentence investigation report. We are here today for sentencing on a single offense of assault, resist, obstruct a police officer. Court has received this PSI. I did not note any need for correction. How about you, Ms. Stahl?
I did not either, Your Honor.
All right, and Mr. Harrison?
I did not see a need for any correction.
All right, thank you very much. Let's turn over to allocution. Ms. Dahl?
Your Honor, I ask the court to follow the recommendation. I don't believe probation is appropriate for this defendant in his history on probation. He was on probation when this offense occurred. He is still pending sentencing and that probation violation. So I don't believe he's a good candidate for probation in this case. I do believe consequences should be given, and 180 days is appropriate for his conduct and his past. Thank you.
All right, thank you. Mr. Stapleton, I did catch one. I'm sorry. I only saw it here now. On CFJ 284A, page 9, when looking at entry 13 of 5th. Oh, wait, no, disregard. I see it. I was wrong.
Okay.
Thank you. Disregard. Mr. Harrison.
Well, I was kind of taken aback, as was Mr. Allen, when we saw that the recommendation was for a 180-day jail sentence on a 0 to 17 guideline. I realized that in a manner of speaking, I suppose, his past conduct is weighed somewhat heavily in this as well. Because really, honestly, if we focus on the events of the night in question, yes, it was a charge of RNO. That's what he pled to. There was nothing physical. There was nothing dangerous to the officers. It was simply, and can't think of a better word than simply, his refusal to come out to allow them to arrest him on the existing warrant for the probation violation in Grand Traverse County. I think in the grand scheme of things, when we look at R&O, look at all the possibilities within that same statute. Obstruct, assault, abscond from. None of that occurred here. There was nothing dangerous that occurred to these peace officers who were obviously just doing their job. He simply didn't come out of the dwelling when they asked him to.
So he barricaded himself in, and he wants to claim that that wasn't dangerous to the officers when they don't know what he's got in there. I don't know what kind of tactical enforcements that they had to bring in to get him out, but no, you can't do that.
That's it. So when you look at the guideline in 0 to 17, I guess my initial reaction should be, there's not much there, and he's already served a significant amount of jail time pursuant to this matter. For some reason, I believe there's an overemphasis here, trying to make this situation, I could be accused of minimizing it, but I don't think so. I think I'm faithfully reciting the content of the narrative into something more dangerous and more substantial than it really is or ought to be. Was it the way we would have him conduct? No, of course not. Of course, there should be a sanction. But 180 days seems like a very strident recommendation under those same facts and circumstances when you boil it all down. We understand he doesn't avail himself of the presumption of no jail here, perhaps, due to the fact, maybe plain and simple, that he was on probation at the time this occurred. That alone, I believe, would provide sufficient good cause for the court to impose a jail sentence. And I would say the court, in reality, probably should, but that jail sentence should be time served and no more. Thank you.
No?
I think I
Oh,
already made
you
my
already did.
argument.
Sorry.
I can.
I've been
but-
going back and forth today, trying to mix it up. Thank you. Sorry about that. Mr. Allen, you have the right to make a statement if you choose. Anything you wish to say?
I think my attorney covered it greatly. There was no violence, there was no lewd actions, no disrespectful terms said, and it was a simple matter of refusal of exiting the building. Thank you.
All right. Well, there might be a little bit of an oversimplification, right? So I highlighted this. The officers were sitting out there watching the Buckley Bar area, which is a common, right? It's a common intersection. People be traveling between Wexford and Grand Traverse County, plus the Buckley Bar and leaving there. You never know what's going to happen. But you left the building, got into the vehicle. No, okay. Well, I'm going to say right now, it says in here, which is uncontested, and I therefore make a finding of the preponderance of the evidence. It says Max then went into the building, came out, got into the F-250, started it. Then he got out of the truck and approached the patrol car. When Max was in the middle of the alley, both deputies got out of the patrol car and started speaking with Max while walking towards him. Deputies informed Max that he had a warrant for his arrest, and that is when he turned and began to run back towards the building. Deputies began to run towards Max and gave him loud verbal commands that they were police and he needed to stop. Max refused to stop, ran into the building, closed the doors behind him. Deputy Ramirez spoke to the door and told him he needed to exit the business and come out with them due to his warrant, but Max refused. He stated he did not have a warrant and he was not going with them. Deputy Ramirez informed Max that he didn't exit the building and follow their commands, he would get charged with resisting and obstructing. Max stated he didn't care. Deputies again informed Max to exit. It says vehicle, I think that meant building, and he refused. And that Ford F-50 250 he was driving had improper plates, improper registration plates, because it belonged to another vehicle. So the defendant, who back in 2024 had been on bond for, actually in 2024, he had a resisting arrest. It was reduced to a disturbing the peace up in Grand Traverse County. Then about 5 months later, he picked up a drivable license suspended. Now, not a big crime according to most people, but that means that this defendant knows he's not supposed to drive a car. By the way, as a driving license suspended second, and yet he doesn't care because he'll do what he wants when he thinks he can get away with it. And then shortly after that, actually, and he was driving without insurance. He picks up the charges in Grand Traverse County, which include operating while intoxicated and another assault resist destructive police officer and operating a vehicle without registration and security. Now, he pleads to an operating while intoxicated, but it doesn't take him long to start violating his probation period, which is probably why they gave him 3 years of probation because of his prior conduct. And sure enough, he went back to his old ways and had some probation violations. Well, also here, I will note that while that last case, the case I just mentioned, was pending, he violated bond by picking up another drivable license suspended, and it was reduced. But I'll note that there was a without security and insurance and registration. So once again, knowing what he's not supposed to do, he does not care, which I'm going to take that as a quote from what he told the officers through the door of the business. He does not care to follow authority. Now, that case was resolved, and it looks like while he was still on probation, he then picks up this case. And I'm going to highlight the defendant drove a vehicle that was unlawfully registered to another vehicle, had plates on it, so he could go to the bar, and then when he saw the cops, he ran inside. So, sir, if you don't like what I'm saying, I'm going to tell you, this is what's in the report, and you did not challenge it. And you're shifting around, and your grumpiness underneath your voice only hurts you. And I'm going to make sure it does. Because what I was going to give you is now going to go up. No, this was not you just resisting leaving a building. Whoever you told that to is wrong. And counsel can look and give me eyes. This report says you will do what you want to do when you think you can get away with it. You've got prior probation violations back in 2016 with your operating while intoxicated. You had other problems here in 2016 because when you were on bond for one drinking and driving, you picked up the next one. and he had multiple bond violations, multiple probation violations. You are not a good candidate for probation according to this court. And you had prior assault, resist, destructive police officers. If you'd only had one, maybe, but you keep doing the same thing over and over again. Other driver licenses suspended. No. No. So, the answer is there are sufficient reasonable grounds based upon your bond violation. And you violated bond here because you didn't go to community corrections when I told you to go, we told you to go to community corrections for testing. You don't follow authority. 32 years of age. You violate bond, violate probation. You ignore the rules. You know you're not supposed to drive, but you keep driving. You put on fake plates on the cars whenever you think you can get away with it. So the answer is you are not a good candidate for probation. And the court will not place you on probation. And your attitude here today demonstrates that my interpretation from this report of what you're like is spot on. So if there's ever an appeal, I wish I could have a video added to the appellate record, but there isn't. But if anybody ever wishes to call the court and talk about it, please do so.
I almost want to call the court just to talk about it, Your Honor.
The court hereby sentences the defendant to a jail term of 365 days, and he gets 121 days of credit. This court thinks the defendant needs to have some more deterrence, and this court thinks he needs to learn some authority and respect. And this court thinks that he keeps getting it light and easy, and this court is no longer going to allow that to happen. I find that that sentence is reasonable and proportionate based upon the factors I've discussed on the record and the entirety of the PSI. Mr. Harrison's going to bring to you 2 copies of one document, and that's, I'm sorry, fines and costs are $68, $130 for the crime victim right fund fee. I'm going to add a $100 cost. I know that's lower. I'm going to add a $500. Nope, I'm going to add just a $100 fine, a $100 attorney fee. Those are much lower than I would typically give. No DNA fees, no supervision fee. Mr. Harrison is presenting you 2 copies of one document. You have the right to file an appeal, but based upon the plea, any appeal is done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, may complete the bottom half of the copy of the documents that you're going to take with you and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy. The copy again in which you place your initials, neither elects nor waives any rights. It merely acknowledges your copy of the document. Thank you very much. We're adjourned.
Ms. Vernon, can you unmute?
Hi.
Good afternoon, ma'am. How are you?
Well, thank you.
Good. Ma'am, the reason you were here today is because we didn't receive your driving record, and so you have a balance due of $215.
Let me ask you a quick question here.
Okay.
Now, I did the whole thing online and I never got it from them. Okay, that's just $40 out of pocket. Then I went through DPS Texas the Texas driver's license, public safety. Yes, public safety.
Department of Public Safety.
Ma'am, and then I went through there and still nothing. I paid my dues and still nothing. So I've shelled out $65 and done what I was supposed to do on my end, but I just never got it. I looked, I kept calling.
So what, I mean, we did grant you an extension back in February.
Right.
But then I don't know that we heard from you after that you hadn't received it. So we gave you an extension, but we didn't hear from you again after February.
Oh yeah, no, I didn't call you guys. I was I didn't call municipal courts. I was calling public safety trying to.
But the court is the one requiring you to produce the document. If you're having trouble getting the document, why wouldn't you call the court and say, I'm having trouble getting this document. Do you have any suggestions? Because I'm sure the court has Seen it all and heard it all.
So we have to have the driving record in order for your driving safety course dismissal to be granted. We can't grant that. That's, that's the statute. I don't,
Yeah, I get that. I just don't know how to get it. I've exhausted all the avenues. I mean, I even went through the state and still I didn't get it. So
yeah,
I don't.
yeah, I mean, there's very specific instructions. And we have a lot of people that are, I mean, it's an unusual situation when you can't get it. I can't explain why you can't get it because most everyone is able to get it and comply with the dismissal. So
So crazy. Yeah, I've been. Okay. All right. So now what is this going to do to points on my driving record?
well, I can't give you any legal advice. I can tell you that it goes on your record as a conviction, but that's already happened.
Oh my God. Oh,
Yeah.
I'm sorry.
It's
I'm
it's
sorry.
already on your record as a conviction. So there's a balance due of 215.
Okay, so basically, I guess I'm just SOL. I mean, I really did do everything I could on my end, and still nothing happened, and I don't know why. They even told me I couldn't come up there. I said, "Well, can I come up there so we can talk in person?" No, 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 no. Don't come. And I'm like, okay. All right, so I need to set up a payment plan. I don't have an
Okay.
extra $200
Okay.
around.
Can you pay $50 by June 19th to start the payment plan?
Yes.
Okay. All right. You're going to see a notification on your screen to join that room, and you'll join that room and they'll give you more information. Okay.
Yes.
Okay. Thank you, ma'am.
Don't get me wrong. She's adorable. She's everybody's grandma. But oh my God. The heck out of me.
Sally Sanders versus Jessica Ostrander, file 26-42263-LT. Who we have present, please?
I'm here, Sally Sanders.
Thank you.
Jessica for the court. My legal last name is Stejkowski, not Ostrander.
Thank you. Court only goes off the documentation it has within the court file, and that's how you were listed in this particular case.
Okay,
Uh,
that's what that's, uh,
That's all right. I'll try to remember that next time. All right. Have the parties tried to talk and resolve this matter?
there was really no talking with Miss Sanders. Actually, there's no talking with Jessica. I have sent in probably a string of 50 texts that I have sent her over since January that she never responds to. She doesn't answer my phone calls either. Her husband was paying the rent and she booted him out. They were behind back in June, last year, and they slipped further and further behind. And I dealt really with him. He was paying. Um, she kicked him out,
All
and
right, Ms. Sanders, hang on. I appreciate you're trying to fill me in on what's happened in the past, but at the moment, all of that's not going to help either side because we're not ready
Okay.
for a trial today. Typically what happens at a first hearing is I decide whether or not the case needs to go to mediation. That is for a chance for the parties to resolve the matter with someone there to try to help them talk in a civil manner to each other. And if that's not going to happen, then I set the matter for a second hearing. And at the second hearing, we have a trial. That is, both sides bring in their witnesses and their evidence. And I decide whether or not there's an entitlement to a judgment. And if so, I'll grant the request, and the eviction date is or a date upon which eviction would be allowed is set after that. Is there any reason why that we should not send this matter to mediation where the two of you can sit down and talk to, and see how you can resolve it?
The house is in foreclosure. I have a buyer buying it as is that would do it in 15 more days. She has never paid me rent. Right now, she owes me about $10,000. My house is in foreclosure, and my Boyne City house may go into foreclosure. I have been paying for her, and she got me arrested on a visit when I told her I was coming on
All
Friday
right,
and
so
came on Sunday
so the
night.
answer is no, you don't want to go to mediation. All right, so.
I don't know, sir. I don't know um how to settle this. I just want her to get out of my house so I can sell it. She hasn't
All right.
paid, never paid. I asked her to give her 30 days in January when she slandered me to a new tenant.
All right, Ms. Ostrander,
Lifelessly slandered me.
Ms. Sanders, I know that this is difficult for you, but I don't need all of the extra stuff. Okay, Ms. Ostrander, is there some
Yes,
reason why you think that you're entitled to stay in the home?
yes, Your Honor. I do not owe Miss Sanders over $10,000. My husband, he has proof of Venmo payments of rent and all that, but she did not summons my husband, Brian Ostrander, to this matter. And he would be more and then she also has made up a new lease that I've never saw before either. So I don't know what's,
So you think that you're caught up on rent?
I'm not saying I'm caught up on rent, but with her harassment and
I'm
also.
gonna tell you the
No,
same thing I told
yes,
her.
yes, Your
Stop,
Honor, I do.
stop, stop. I should not have to say that 3 times to an adult. This is neither the time nor the place for the two of you to get into it. And I don't think you want to get into it with me. Answer my questions. That's all I need to know. If we want to have a trial, we'll have a trial in the future. That's when you can talk. Today is for me to figure out what we need to do. That's all I'm going to do today. So the question was, are you caught up on rent?
No, sir.
All right, then she is entitled to ask you to leave. You can certainly make a record at trial of what the balance is and what the payment record is. Okay, and both of you would be required to bring in your records to do that.
Mhm.
So I'm
Great.
going to stop.
Sorry.
I'm going to tell you right now, you both do this in front of me in person, and I'll hold you in contempt of court and let you sit in jail for a day. You don't get to talk whenever you want to talk, however you want to talk in court. This is not the street corner. This is not your house. Act like you're in court. I'm going to set this for a trial. That's going to be in person. You're going to come to the courthouse on the date and day that I tell you to. Bring any witness that you want to bring. Bring all of your documentation with you. If you don't have it, we're not going to adjourn for you to go get it. If you need it, if you want it, bring it. Does everybody understand that?
Yes,
Yes,
Your
sir.
Honor.
In order to allow you both to gather your documentation, I'm going to set this out a little bit. I'm going to give you a couple of dates. Pick the one that's best for you, and I'll try to resolve if you can't pick the same one. I have June 29th, July 13th, or July 20th. Ms. Sanders, which one is best for you?
June 29th.
Ms.
Your Honor, Your Honor,
Stajikowski?
she has no records. My records are completely together. They want to buy this, and I'm in foreclosure. I'm a disabled vet. I can prove that they owe me $10,000. They don't have any Venmo proof.
Ms. Sanders, even if everything that you tell me is true, it doesn't help you today. She's still with us. Ms. Stajikowski, is the 29th sufficient for your needs?
Yes, that'll be quite all right with me, Your Honor.
We're gonna set the trial date for June 29th. I'm gonna set it for 3:30. That will be in person at the district court in Gaylord. Do you know where that's at?
Yes,
Up
Your
by the high
Honor.
school?
Yes,
right.
Your Honor, I do. Thank you.
I'll see both parties then. We'll send a notice out to you and to Ms. Sanders. That's all for today,
Thank you, Your Honor. Have a great day.
too. Ms. Sanders, I see that you're back.
I
All right. We lost you there for a minute, so all I did was set this matter for a in-person hearing here at the courthouse on June the 29th at 3:30.
what happened to the 22nd?
Um,
The sooner the better, sir. It's in foreclosure and the new owners want it now. I need the money so bad. I'm a disabled vet. She's been putting me
okay,
through
Ms. Sanders,
Yeah.
I'm not discounting anything that you're telling me, but what you're telling me right now isn't gonna help anybody because there's nothing I can do about it. All I can do is set the hearing as soon as I can. So June 29th at 3:30, you will need to be here in the courtroom, ready to present your case, and I will do it at that time. And I will listen to everything that you have to say that's relevant at that time. All right, ma'am?
How soon so I can tell the owners after because I know that she has no documentation of shows payment.
I will
And
make
I
a
have
decision
kid.
that day. So June the 29th at 3:30 is when the hearing will start. I'll make a decision as soon as we're done with the case, and you'll know what's going to happen on that date.
And remember, ma'am, he said he will listen to anything relevant. Very important words that he added there. So yeah, be ready to only discuss relevant things.
Okay, thank you.
I'll see you then. Thank you.
Okay.
Chloe, can you unmute? There you
Sorry,
go.
I was going to the restroom.
Okay. All right. Ma'am, you have two cases. You owe a total of $440. What are you requesting today?
I am not entirely sure what my options are because I can't really afford to pay the tickets. I've been telling them about it since last year. I've maintained the financial responsibility and on the additional requirements. I want to see if there was any like community service or anything else I could do to substitute for that high payment since I just simply cannot afford it.
Okay. If you were on a payment plan, could you do the payment plan?
I honestly do not think so.
Okay. Do you
Like
have
I'm trying to be completely honest. I work full time. I'm also a student and I only make 18 an hour and I pay for everything myself. So it's really hard, especially right now, to find any leeway.
Okay. Well, looks like you were placed on a payment plan in March. And so I guess you didn't make any payments from that payment plan, correct?
I guess I don't remember. I know last time I came in, they told me they would email me more documentation and I never got another email. So it could have been that. But I was waiting for it after the last time I came in.
Okay. Well, I was on the bench that day and the notes are my initials. So I say that I gave you an extension anyway. So you're saying even if you're put on a payment plan, you can't pay it. So you already have, these are already convictions. So, I mean, if you're saying the only way you can do it is to do community service, let me tell you how many hours of community service that would be, okay?
Okay.
That's going to be 23 hours of community service.
I can do that.
Okay. So that's going to be due, the 23 hours is It's going to be due by August 15th, okay?
Okay. And I already volunteer with some place. Will I have to get like an additional approval for a certain place from you guys, or can I just
No, I
let
mean,
them
if
know?
it's a nonprofit organization, we will accept it, but you're going to see a notification on your screen to join another room, and they'll give you information about the community service, okay?
Okay, thank you so much.
Okay. All right, can you hear me?
Yes, ma'am.
All right, sir, the reason you are here today is because you owe a balance of $225 on your citation. Are you requesting a payment plan?
Will they let me do community service for that? Cause I'm in a financial downfall at the moment. That's why
Okay,
I haven't been able to pay it.
okay, just a second.
So did my other one go
Just
through?
just
Oh, I'm
one
sorry.
second, sir.
I'm sorry, man.
All right, sir, it looks like I think you're referring to a speeding you're here for the violation of the DL restriction, but you had another case that you never submitted your community service. You
Yeah,
were
I
granted,
did. I did submit it online. It should have been submitted on there.
um,
Cause I went right here to the Salvation Army and everything.
when did you submit it?
It was like probably like right around the time it was due. I don't remember the exact date, but I for sure submitted that.
I see there was an order for community service issued in February, but I don't see community service submitted. Just one second.
I put it.
You submitted it online?
Yes, ma'am. I told me to do it online.
Okay. I I I don't see it here. Do you still have a copy of that?
I mean, I probably got a photo, or I think I took a photo of it. I want to say,
Okay. Well, if you can submit that to us, and then on the other case, the community service hours, let me tell you how many it's going to be, okay?
okay.
You're going to need to do 12 hours of community service. So the other one, I think you had
He
7
gave me
hours.
7 hours.
Okay, so I'm going to tell you, you need to get the 12 hours submitted by July 15th.
Okay.
And then you need to get the other one submitted to us by June 15th, showing that you did that, okay?
But so if I can't find it, like because the Salvation Army for sure got the sign in, because the record of it. If I can just get her to re-sign it and resend it, would that be fine too? Because I
Yes,
for
if you
sure
can get
did
them,
it.
if you can get that submitted, we need it by the 15th. Okay, and then the 7 hours that you did needs to be submitted by June 15th, and this 12 hours is due by July 15th, okay?
July. Okay, yeah, that's perfect right there.
Okay, you're going to see a notification on your screen to join another room. Join that room and they'll give you more information, okay?
All righty, thank you, ma'am.
Thank you.
All right, our next case this morning is going to be people in the state of Michigan versus Adris Malai. Molly, sorry, I knew I was going to get that wrong. This is a case number it's only 4 letters too. 26-14234 FH. Appearances from council.
Joanna Carey for the people. Good morning, Your Honor. Marie Vandenberg on behalf of Mr. Molly, who is present to my left.
All right, thank you. And also here, you can see Mr. Molly. Mr. Molly is currently in pretrial custody. He's been brought here into court, and we've got the infamous Kevin Stepleton standing in here today for our Department of Corrections PSI. We have the report. I'm going to take just a quick look to see if I made any notes in it. All right, looks like I did not note any need for correction. Ms. Carey. And Ms. Vandenberg.
Your Honor, just for the record, because I had a discussion with my client about a week ago at the Wexford County Jail, and I did say to him that I would challenge PRV 5, which scored at 2, but in further investigation with regard to the HYTA status, I understand now there's a Court of Appeals decision with regard, and it is allowed to score.
Yeah.
So other than that.
It does seem odd. When I read that opinion, I was kind of scratched my head, but it's okay. All right, thank you. Anything else in the bottom of the report?
No, Your Honor, not about it.
All right, great, thank you. I'm going to turn now to the state of Michigan. Are you feeling better today, by the way? Friday was rough. No, something is going around. I can tell you, and it knocks you out for about a week. All right, go ahead.
I would ask the court to follow the recommendation.
All right, thank you very much. And Ms. Vandenberg.
Yes, thank you, Your Honor. I don't know whether the court is in, I wrote a very short.
Yep, I've got it right here.
Memorandum.
Yep, it was received, by the way, it was received in my office, I think, last Wednesday, and I did review that. Thank you very much.
Well, thank you, Your Honor. I just to reiterate what I've already written, and also a copy to the prosecutor, to Ms. Carey. Mr. Molly is 26 years old, as the court is aware, and that's in the pre-sentence report. It's troubling, you know, to Mr. Molly, to myself, and certainly to the court, that Mr. Molly, this is now his third drug conviction. He had HYTA, was granted HYTA, but then that was revoked because of a conviction. He spent 6 months in the Manistee County Jail as a result, lost his HYTA status. I believe, though, and speaking at length with Mr. Molly, I agree with the Department of Corrections, and that is that he was very pleasant. He's a very pleasant young man. Again, he's only 26 years old, and he has a long life to live if all goes well. He has three strikes, so to speak. So 3 felony convictions that he's going to have to live with for a period of time. And provided all goes well with him, in about 5 years, maybe it could be expunged. And Your Honor, I make no excuses for Mr. Molly, and neither does Mr. Molly. But he spent 85 days in jail as a result of this conviction, but he's been incarcerated for a total of about 209 days. And that would include the Manistee matter and a matter before Grand Traverse County. In that county, Mr. Molly pled guilty to possession of an analog. There's no doubt that Mr. Molly has had some issues with regard to substance abuse. Initially, I think he made light of it, didn't really understand it, but since incarceration, he's availed himself of several programs. He now has a better focus on life, a better direction, I think, with regard to his future. He has some great plans for his future. And I'm asking the court, I know the recommendation is a lengthy period of incarceration, guidelines for where they score. And the court doesn't take these cases lightly. I understand that and respect that, Your Honor. But I would ask the court to consider the fact that Mr. Molly has already spent about 209 days of incarceration total. And I don't expect this young man to repeat this behavior. I think he's on the right path now. And I think that he'll have the tools. He's gained the tools in Wexford County Jail, and he'll continue that, Your Honor. He does have a bright future. I believe in him. I've known him for a number of years now. And again, I can't say anything other than what I've already said and what I've already indicated in the pre-sentence report. So, Your Honor, I'm asking the court, Mr. Molly is at the court's mercy, and we know that, and we're asking for mercy, Your Honor. And one other thing, Your Honor, and I'll just say this very quickly. The court understands and knows this as well, that probation is an act of mercy and grace. And so we're asking for mercy and grace at this one time for this young man. Thank you very much, Your Honor.
Thank you. All right, Mr. Molly, you have the right to make a statement if you choose to do so. Is there anything you wish to say today before I issue a sentence?
Yes.
All right.
So, good morning, Your Honor.
Morning.
My name is Idris Malley. I thought about reading a paper, but I would rather just speak from the heart.
All right.
So
Oh my gosh, that was the worst acting I've ever seen in my life. That among those classes that he's going to be able to get in jail are acting classes part of that lineup, because that was terrible. You could tell that was so pre-planned. Oh, I'm gonna pull out this little piece of paper. I'm gonna look at it, shake it a little bit, and then set it down and tell the judge I'm gonna speak from the heart. Like I haven't rehearsed it 1,000 times in my cell, waiting for this very moment. Man, you don't get an Oscar, you don't get a Grammy, you don't even get one of those little participation trophies. Like, no way, man.
For these past couple of months, I've been incarcerated. I've learned a lot of things, and I've had a problem. I struggle with substance abuse, and I'm understanding a lot more about my problem. It's affected my family, my friends. I've burned a lot of bridges. It had serious consequences. Just asking for another chance. I have plans when I'm upon my release to attend outpatient. I'm working with CHS from Manistee, also in Wexford. I also go to the AA classes. I've learned a lot from those groups and meetings with everybody. If I am released, if possible, I would like to continue schooling and do trade school and get my builder's license. Just show everybody that I'm a changed person and I want to do good for not just me, but the community.
Well, let's cut around the one thing that everyone else is talking around and not talking about. How did you get out to Boone at the county store with an ounce of cocaine, nearly $1,000 worth of cocaine? Because you weren't out there using it. You don't live here. We all know what the report says, which I make a finding of preponderance that the facts contained in that report are accurate. So this is not about your use, right? Who sent you to deliver cocaine into Wexford County out in Boone? I ride by here 4 or 5 times a week. I know the county very well. I know the county inside and out. What brought you over here? Who sent you with the cocaine?
No one sent me out.
Okay.
I take full responsibility
Good.
for my actions and what is wrong.
If there is anybody, you can tell them to stop doing it. So, all right. So, yeah, this is not about you using cocaine. I mean, yeah, I can look and see that I've got a 26-year-old man here in front of me who has been using marijuana since he was about 18. Started drinking in 2021 and has also been supplementing it with cocaine for the last 3 years. So, and you've gotten in trouble and you've had mercy in the past. In 2017, you were given HYTA status. Thankfully, you completed that successfully. And then in 2023, you pick up possession with intent to deliver, means drug dealing. And then you violated probation here. And the disposition in the last case was done on May 20th of 2024. And then you violated your probation September of 2025. And then when you violated it, you picked up this possession of cocaine, which you pled to an analog. And then you, at about the same time, actually, you were arrested on, and there's another thing we haven't talked about yet, in entry 3 of 4 in your criminal history on CFJ 284A page 4, that offense date was marked again September 24th of 2025. You were arrested that same day. Then apparently you got bond, right?
You said, yeah.
Yeah. In entry 3 of 4. On September 24th of 2025, you were arrested for possession of cocaine. You pled on that case about 7 months later on April 24th of this year. Now, what I can tell here is because the arrest date was September 24th, and then this offense date occurred less than 2 months later, 6 weeks. You were not only on probation, but also on bond. Now, nobody's asking for it, I'm not going to, but I'm going to tell you, because this is a possession, I could sentence you consecutively. And if you had pled to the delivery, I'd have to sentence you consecutively. So this is not about you and your use. Do you know anybody who lives out in Boone that you come and visit regularly?
Yes.
All right. Well, according to the report here, you're a drug dealer, and it's the second time you've been picked up for cases related to it. Now, again, the last one was, so you had the possession of cocaine, we talked about that one, and the one before that was a possession with intent to deliver. Now, while it was pled down from fentanyl to a counterfeit substance, it still was possession with intent to deliver. Let's not ignore this. This is not about substance abuse. You might be pleasant. I'm sure you probably are. Doesn't mean that you're, people who use aren't necessarily bad. People who may be addicted aren't necessarily bad people. That's not my point. 66% of my caseload is criminal, and of that 66%, another 66% is just methamphetamine, cocaine, and fentanyl. It is the #1 criminal problem in our county. #1. And it's a disease. It's like walking around and spreading COVID, HIV, whatever. You're spreading a disease. It results, I will argue this till I am dead. It is not a victimless crime. It hurts families, it hurts communities, it destroys people, it destroys families, it ripples onto children, it makes workplaces more dangerous. No, I don't, this does not make it issue. I've never had a problem, but I'll tell you, I ride up and down that road almost 3 days, 4 days a week. Road out through Boone, cut over, then go out to Harrietta, and then keep going, then go over to Manistee County line. And it makes people who are who are out there at risk. So the answer is no. At least in some of it. The question I don't really know what is, but we talked around it. So when we talk about rehabilitation and stuff like that, you might have, it does look like you have a drug and alcohol and marijuana problem. You also have a bad choice problem of being a drug dealer, and that's not acceptable. All right. And I'm lecturing because I don't know, so far the other judges haven't gotten through to you. So I'm going to get through to you. You've got probation violations. You've obviously got a bond violation. You keep committing the same kinds of offenses. So,
No, I speak with regard to the bond violation.
yeah, sure.
Okay.
I'm not going to set them consecutively. I'm just saying, I'm trying to highlight for him what this means when he keeps making bad choices. But yes, you can.
Thank you very much, Your Honor. And Mr. Molly can correct me if I'm wrong, but my understanding of the bond violation is that Mr. Molly there was a facility, or it used to be a facility in Muskegon County that is no longer operating. So when he was to call for drug testing in that facility's closed. My understanding that Mr. Molly left, is that correct? Three voicemail messages to community corrections and didn't get a call back, and of course things just then dropped the ball. So I just wanted to make that clear because I didn't speak to him.
I understand.
For the opportunity.
I understand that. The point here again is it's still the same kind of violations.
Yeah.
So while the court has to recognize that the law says that for a intermediate sanction cell, the court starts with a rebuttable presumption of fines and costs and probation only. I also recognize that the probation statute says that courts are to give probation when we don't think someone is going to keep reoffending. It doesn't make sense to me that the legislature says I have to start off with a presumption. But the court notes that, again, we've got repetitive criminal activity that's not only involving youth, that is also involving drug dealing. And you got a significant benefit. I don't challenge that, by the way. I'm not criticizing the prosecutor. They've got a lot of work to do. And I don't criticize. I read the report that Ms. Vanderburg presented. But today, I'm making this a little bit of, no, really, about what it is. A young man coming over here to spread addiction. Probably doesn't need much help because he got problems, but still. All right, the court sentences the defendant as follows. I'm going to place the defendant on a period of probation for 36 months. Court adopts the terms and conditions that are listed on CFJ 145, pages 2 and 3. I find that they're well suited for rehabilitation purposes. Now, when it says not to use or possess alcoholic beverages or other intoxicants and or controlled substances, that includes marijuana. You can't drink it. You can't smoke it. You can't use any controlled substance. And I'm unlike, maybe from what I hear, other judges, you do not want to test positive. All right. The court assesses a $68 state minimum fee, $130 crime victims' right fund fee for the processing of this case throughout the court. So I'm going to assess a $300 court cost. I'm going to assess do we have a restitution for the $900 or was that? So there's $900 and that's going to be payable to the Traverse Narcotics team. The court's going to assess a $500 fine. An attorney fee is not needed because Ms. Vandenberg is retained. And did we already, I assume we already had DNA, so that should have, no? Did I don't.
DNA fee. $60.
Did we do a DNA fee swap over in the jail? Yeah, all right. All right, so we'll do a DNA fee that's payable to the Wexford County Sheriff Department. And there's supervision fees of $30 a month or $60 a month if there's any electronic monitoring. That leaves the question about what to do with the defendant for a period of confinement. This court sentences the defendant, but it is within the it will be within the guideline range. However, I've already stated the grounds for the reasonable presumption. And I will the court gives the defendant a 330-day jail sentence, which is basically 11 months with 85 days of credit. This was an ounce of cocaine. You have been convicted and they did not give you the grace and had stuck you with a delivery, you would have gone to prison and you wouldn't have gotten good conduct time. I want you to tell any friend you know, any person you know, do not do what I did. Part of the criminal law is about deterrence, not only to you, but to other people. Spread the word. Not deliver in Wexford County. Now, I will say this, Mr. Molly, I don't know you, never seen you before. I mean, other than in relationship to this case. I know I can sound like an ass. I really don't want to. Because quite honestly, I would rather, it sounds funny, I'd rather pat you in the back and put my arm around you and say, dude, stop listening to the idiots in your life, right? You can be a good person. You probably are a good person. Stop those idiots. Go get a job. Or what it is. An honest, good paying, an honest paying job. And don't do this. You're young. You got plenty of life to live and put this behind you. Maybe become a peer recovery coach. Maybe become somebody who volunteers at a program. Maybe somebody who starts or works with a 501c3 charitable program. You can fix this and put this behind you. I really honestly believe it. And no matter what my words are, because by the way, I'm always trying to figure out what I can say and maybe get into the little person inside of you. I don't know if I do it right. I've got no idea. Don't tell me if I did it wrong. So anyways, that's the sense of the report. Ms. Vandenberg's going to bring you 2 copies of one document. You're going to place your initials on the first copy. Doing so neither elects nor waives any rights. It merely acknowledges your receipt of the copy of the document. This document tells you that you have the right to appeal the conviction case. Based upon the plea in this case, any appeal must be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to consider appointing an attorney to assist you, you may complete the bottom half of the document and return to this court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. All fines and costs are due within 56 days, or a 20% penalty will be added. However, as long as you are making payments, this court will waive that 20% penalty. You also have the right to be considered for release from your probation early at halftime if you are successful with all your terms and conditions, which means if you comply and do everything right, you won't be on probation for 36 months. It'll be 18 months. And I really hope I get to sign that piece of paper saying, yep, he's off because he did great. And that's what I want to see from you. All right. Thank you all very much.
Thank you.
Thank you. We are adjourned. All right. Oh.
That's the, are we just gonna continue the bench warrant?
We're just leaving the warrant. Yeah, she's supposed to turn herself in.
You. All right. Our next case this morning, oh, here's that, is going to be People of the State of Michigan versus Levi Evans Spears. The case number here is 26-14201-FH. Let's begin with appearances, please.
On behalf of the people. I'm Jeff Pierce. On behalf of Mr. Spears, he's making his way to the courtroom.
Spears is now at defense table and is currently in pre-trial custody. We have Mr. Sean Bonatmo. He is the agent from the Michigan Department of Corrections, who has prepared today's pre-sentence investigation report. And let's take a quick look at it. I'm going to check to see if I made any notes for any potential corrections. All right. Oops. I did not note any need for correction. Let's turn it over to the people. Mr. Carnes?
Your Honor, I did notice OV12 being stored at one point. I know this goes against my cause, but I don't think it should be stored. Reading the police report, you know, I thought about, well, can I charge a flee and elude or an RNO here? There's no lights going on in time, and when police did catch up, it was cooperative. So I think it's safer to just store that.
I assume the defense has no objection.
The only objection that I have is that he said it instead of me.
All right, well, I can have Nancy redact the.
I'll withdraw my comment.
Not necessary.
All right, we're going to strike OV12, change that from 1 down to 0 points. I'm going to assume, however, that doesn't have any impact on the guidelines. All right, thank you. Any other amendments, corrections, or objections to make?
No,
Okay.
Your Honor.
All right, thank you. I turn it now over to Mr. Harrison. Sir?
I have no further proposed corrections or alterations.
All right, thank you. Allocution then, Mr. Harris, Spoke Carnes. Mr. Carnes, anything else?
Thank you, Your Honor. The victim is here with us in the courtroom. He doesn't want to speak, but this was a horrific crime for him. I have spoken with him in the past. This was his truck. I mean, he needed this to get to work every day.
Yeah.
And the defendant, while drunk, stole it out of his driveway. Many of us turn our vehicles on in the wintertime in Michigan so we can drive to work warmth. And apparently it's not safe to do that. That is very unfortunate.
Or just make sure it starts.
Yeah, depending on the condition. But this was a extreme financial hardship to the victim, and I really think this is a case where the sentencing reforms are not at all fair to the victim, considering everything that happened here and crashing a stolen vehicle while you're drunk. seems like the sort of offense that should be punishable by some serious time. I also recognize the position we're in now with that sentencing reform. I do think additional jail time is appropriate. But primarily here, I think 36 months probation is appropriate because the defendant committed this offense while drunk. And then while he was on bond, he was caught with a container of urine at community corrections. And subsequent to that being found, he tested positive for fentanyl. So the defendant is extremely dangerous to the public, both financially and physically, as this was a drunken crash. It could have easily injured someone. Thank God it didn't. So I think the 36 months probation is important to make sure the defendant is not using substances. And again, I think additional jail time is appropriate. Thank you.
Thank you. Mr. Harrison?
Well, Your Honor, I agree that some intervention is necessary here. I don't believe that intervention should consist of further jail time. Clearly, Mr. Spears needs some guidance with regard to impulse control. He needs some guidance with regard to substance use disorder, whether it's alcohol, or narcotics, or a combination of both. Unfortunately, the resources that we have available to him in jail, I don't believe are sufficient to address the magnitude of his issue, especially with regard to impulse control and perhaps anger management, that sort of thing. This was, I understand, and I don't mean to belittle the victim or to downplay the significance of these events in his life, but taken in isolation, this was an unbelievable act of stupidity on the part of Mr. Spears. One thing you could look at is his relatively youthful, like the facial tattoos. He is an extremely young offender, and I say that, use that hyperbole for a reason, Your Honor, because he has a significant record with regard to brushes with the law and acts that are clearly the product of poor decision-making at his young age. The court may or may not be familiar with Mr. Spears' background, but one of the things that I've talked to him about is the fact that I think for under his circumstances, he's actually doing fairly well. He has had little to no structure in his life since about the age of 12 and has left to make his own decisions without anyone really standing there saying, Levi, you sure you want to do that kind of thing? That doesn't make him a bad person. That doesn't make him, frankly, what I would see as a dangerous person. What it makes him is a person in need of guidance. And I, for one, am fairly impressed, although the shenanigans with the fake urine, blah, 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 I think attest more to his youth and immaturity than they do to any evil motive on his part. He knew that he would still have drugs in his system. He knew that that was going to be a problem with his bond. He didn't, in his act of desperation, want to jeopardize that. So he made a poor decision. And let's examine the circumstances of that, Your Honor, because it was not difficult to apprehend him and determine exactly what he had intended to do. And in fact, made it all the way to community corrections through a very short investigation involving text messages on his own phone under his own name. I wish there were words that I could employ in a better way that would give you a better illustration of the kind of thing that I'm talking about, because I think a lot of times when I start giving the court an explanation about, well, come on, Judge, let's look at the totality of the circumstances here, it comes off to the court and maybe the people on YouTube or in the courtroom as though I'm trying to make excuses for Mr. Spears, and I guess in a way, that's sort of my job. I don't make any excuses. I told you flat out, and he told me flat out, and then maybe not in so many words, that this was a really dumb thing to do. But his thinking was cluttered by his use of alcohol. His thinking was cluttered by his use of controlled substances. His thinking was cluttered by his inability to control impulses on certain occasions.
But he felt that he was, perfectly fine to steal a truck and drive it drunk.
What do we do at the end of the day? It's one thing to say, well, let's put him in jail and throw away the key. Well, that doesn't seem to make any sense. The sentence guidelines are what they are for a UDAA. Certainly the legislature contemplated that there would be collateral damage in any number of these cases, but that nevertheless generates a guideline of 0 to 9 for Mr. Spears in this case. I think the recommendation for 150 days seems to be in line with the guidelines in as much as it overrides the presumption that he would not go to jail in the first place. This was not a crime of violence. He's still entitled to that presumption. If guidelines are to be adhered to, I think I would recommend to the court that it fashion a sentence more along the lines of that and allow Mr. Spears the opportunity, and I use this term reluctantly, to grow from this experience. Thank you.
Mr. Spears, you have the right to make a statement if you choose to do so. Anything you wish to say?
I'd just like to apologize for the understanding that I deserve what I did.
Well, was there any leftover restitution I need to address? I looked for it. I was looking. I didn't see
Your
it.
Honor, I looked for it on Friday, and quite frankly, Ms. Frick and I need to follow up with Justin. So I just asked to reserve that right because there was some, well, actually I have. I'm sorry.
I know there's information about the insurance if you, yeah. I'll leave restitution open.
Oh, well.
Wait.
I was looking for this and I have it. We're requesting $12,618.32 in restitution. 100 of that to
1,200.
12,000.
12,000. Sorry.
$618.32. That's $100 to Justin Sisson and $12,518.32 to State Farm claims.
All right. Well, this is where potentially, one could argue that the way the law is I can't make justice magically happen. The court's going to make 2 restitution orders, $100 to victim here, Justin, is it Sisney? Cissney? Yes. All right. And the other $12,518.32 to State Farm. But I'm not, well, yeah. We know that the defendant's not ever going to likely pay that. He has had some work history, but it's a bit sporadic, and I don't know how well he's doing. Unfortunately, though, he can afford alcohol, opiates, marijuana, and methamphetamine. But we're going to make sure that he's not spending any money on those items while he's on probation. The defendants, Mr. Harrison might be right. I have a young man who is now 23 who has had no structure since the age of 12. Well, the maximum amount of structure I can give him is 36 months of probation. That's what I placed him on. The court adopts the terms and conditions that are listed inside the pre-sentence investigation report. As this, the probation is only going to apply obviously to count 1, Madam Clerk, when I adopt all the remaining terms and conditions, I find that they are well suited for rehabilitative purposes. The court assesses the $68 state minimum fee for the felony, the $50 state fee for the misdemeanor, $130 crime victims' right fund fee, a $300 court cost. The court is only going to order a $200 fine as a way to try to encourage them to make some payments toward that restitution. The attorney fee here is, I'm just going to order it to be $300. Supervision fees are $30 a month or $60 a month if there's any electronic monitoring. Do we have to do DNA here?
No, Your Honor.
No, so there is no DNA fee, and I already covered the restitution. The thing here is, this is not merely, I understand the defendant, Mr. Spears, does not have guidance. Fix that. I can do the best by giving him the most the government will allow me, and that's 36 months of probation. Is that going to fix it? I've got no idea. But that's what I'm doing. So this is not merely about dumb ideas. This is about a young man who is continuing to lead his life down the wrong path, and I don't know how else to get his attention. Now, he's got a relatively minor criminal history, but his first entry in 2021, he was on bond, picked up a flee and elude. So right away, he started off with some felonies, and he violated probation relatively soon after. And he was sentenced on January 10th of 2022, and he was violating probation within two months, and then again 2 months after that. Entry 3 of 5, which was a malicious destruction of property, occurred while on bond for the previous case. So he violates bond twice right away, starts violating probation right away. He does get some case here dismissed in 2024, but now he's back to this. And so these are crimes where he just does what he wants. And then the lying to the court and deceiving the court on the bond issues, trying to get other people to come in and provide you urine. That's just stupid and selfish and deceptive. Maybe not evil. I think that was the word Mr. Harrison used, said you weren't evil, but it sure is demonstrating that you're a selfish and a liar. I really hope that changes. I think you can. I hope you can. The best the law allows me to do is put you on 36 months of probation. Now, there is an intermediate, first of all, for the misdemeanor Madam Clerk, it's 93 days with the 117 days of credit. Then again, the intermediate sanction cell, 0 to 9 months. Other people in trouble. Didn't take long to figure out what you were doing. And you weren't held in contempt, but your bond was violated. And so I don't know what it's going to take. So I'm going to tell you, the best thing I can do is maybe start to send some message of deterrence, because forgiveness and feeling bad about your childhood isn't helping. Only you can fix that. As to count 1, the court finds that there are reasonable grounds and that the sentence I'm about to announce is proportional and reasonable, based upon the facts, based upon his violations of bond, both prior to this case and while this case was pending. The fact that this involved you crashing another person's vehicle, causing more damage to the vehicle than you probably have made in a while. That's just unacceptable. You could have killed somebody. You were on 130, the main drag through town. Well, the court sentenced the defendant there to 180 days of jail with 117 days of credit. All right, that means that the defendant has about 33 more, no wait, 33 more days to serve, if I did my math correctly in my head. Don't count on it. All right, have I missed anything, Mr. Van Amel? Mr. Carnes? Mr. Spears, Mr. Harris is bringing you 2 copies of one document. This document tells you that you have the right to appeal the conviction and sentence in your case. That is typically done by filing a claim of right to appeal. However, based upon the plea in this case, any appeal must be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, may complete the bottom half and return to court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. All fines and costs are due within 56 days. However, as long as you're making payments while you're on probation, the court will waive that penalty. You have the right to be considered for early release from your probation at halftime if you're successful. I truly hope that you are successful. It's a better idea that if you're having cravings and you're having thoughts of doing something stupid, go to Mr. Van Ettel. Ask him. Hey, I need help with something. I don't want to do something stupid because I know Judge Elmore can be a jerk. Which I can be, but it's never intended. You don't have to laugh. It's not intended to be a jerk, Levi. Oh no, no, I can tell you, I don't know, you're not my son, but you're younger than mine. I never knew how well to discipline him. I didn't know if I was supposed to put my arm around him every time or be rough on him every time. It's a crapshoot, and it's even more difficult for a judge because I don't know you. I really, really sincerely want you to do better. I really think there's a good person there. I never believe that people are entirely bad. Whatever has poorly happened to you, it's done. I wish I could go back and change it. I can't. You can change how you act. You can change the choices you make. I really hope that you do. Right? I remember the young girl that was in here, and she seemed to like it. So, Mr. Van Ettel, he'll help you. Mr. Harrison, you might want to stay away from him. But anyways, all right. That's the sentence of the court today, and I do sincerely wish you the best. We are hereby adjourned. Thank you.
Yeah, approved.
You may, sir. Thank you. Our next file this morning is People of the State of Michigan versus Brooke Halliday. Now, the file number is 25-14132FH. Let's begin with appearances.
On behalf of the people. Halliday. She is in pretrial
All right.
custody.
Mr. Van Amel is here. Are you standing in for Mr. Potter? All right, thank you.
Here she comes.
All right. Let's see. All right, Ms. Halliday is making her way to the defense table. We have a sentencing here today. I've looked at the pre-sentence investigation report. There really wasn't a whole lot to talk about. I mean, the description of the offense is only one short paragraph. But, the court has also recognizes that there was a prior PSI from a very recent case also attached to it. And it's gone also over the scoring of the guidelines and the criminal history. Mr. Carnes, any amendments, corrections, or objections to make to the contents of this report?
Your Honor, on page 15.
Yep, that's in the CFJ 284.
Yes. Yeah,
What is that? Is there a page 15 in the new report?
No, Your Honor, this is in the old one, so I'm
Yeah.
not sure if it's proper.
Let's take a look at the old one. See, it is, because make sure what it, well, because they don't put this section, I think, in the updated version,
That's correct.
right? So go ahead, tell them what you got.
So I noted methamphetamine start use date of 2001 in the table on page 15, but then in the narrative on page 16, it's reported that she began in 2007. So I just noticed that one of those 2 dates has to be wrong.
Pick one. Mr. Harrison? I don't know. And by the way, Mr. Carnes, you can also reference, we can make the amendment as the CFJ 145, page 1, which also includes that same chart. Did it begin in 2001 or 2007?
2021 then?
Yeah, 2020.
Well, methamphetamine. It says 2001, or it also said 2007. Yeah, it says methamphetamine use was reported at the beginning of 2007. Here's where I think there may be an issue. Through 2016, and then I assume it began again in 2020? No?
The first time was in 2020.
Oh, okay. Well, we'll make a note of that. All right, Mr. Van Atmel, let's see if you can make that change there. Maybe at least on the CFJ 145, page 1 portion. All right, thank you. Anything else, Mr. Carnes?
No, Your Honor, thank you.
How about you, Mr. Harrison?
I have no corrections. Well, actually, I do. I have a question. It revolves around jail credit.
Okay, let's take a look at it. Looks like she had bond revoked. So, wait, hold on.
There's a split and there's some time from April until June.
Right. So it looks like, did she get a conviction in district court?
She did.
So she wouldn't get credit.
But the point that I'd like to make is the conviction in the district court was part and parcel of a plea agreement that she would enter in this court. So by the same logic that we sometimes use in assessing
So here's
probation
what,
violation.
yeah, so here's what I think I can do. I don't think I changed the credit. I think you make the argument that she pled to both cases as part of one deal. And then I'm not gonna tell you how to argue, but I would think to myself as a judge, well, hold on, that's what I'm thinking right now. Jesus, why
Yeah,
talk about
I'm
myself?
just teeing that up, Your Honor. It's
All
an
right.
issue.
But you could have tried to adjourn the sentencing and get the sentencing done the same day, yada, yada, yada. All right, I got the argument.
Yeah, in
I've got the
theory, I
argument.
could have. It's further complicated because she was represented by Haraya Niegos in the district
Okay.
court matter.
All right, and let's talk, anything else changed? I think that's
Nothing
right.
of substance, Your Honor, no.
Let's go ahead and turn to Mr. Harrison since he's doing the talking now. Allocution then, sir.
Miss me?
That's you.
Oh, I'm sorry.
That's okay.
Went to the Bahamas for a minute.
Sometimes I go back and forth just to see if you guys are all paying attention.
Yeah, well, apparently we were not. The royal we. I'm stammering a little bit, which is somewhat out of character for me because I really don't know the answer to the puzzle that is Brooke Renee Halliday. Clearly, she has an issue with substance abuse and needs to address it. She has expended a great deal of effort to, and successfully so, obtain a placement in a rehabilitation facility as we speak. That bed would be available to her momentarily. Then we have a guideline of 9 to 23, and I guess our gut reaction, hers and mine, was at least in prison I can get treatment. Then we have what I believe to be sort of an odd recommendation for a county year, which quite frankly is the least attractive of the options available to her. Does have further entanglements in Grand Traverse County. Unfortunately, she is already on probation in Grand Traverse County. You're not now?
Yeah.
She just started, right.
Yeah, I saw that the conviction was last month, time served in probation.
Right, right. I want to make sure I have it right. So as far as providing guidance to the court about what should happen, here is what I would present to be the perfect storm scenario for this situation, for her situation, is that she not owe Wexford any more time.
So the perfect storm for her is a hurricane that just wipes everything out? Doesn't seem fair.
That she not owe Wexford any obligations with regard to probation. And that she be left to deal with the pending case in Grand Traverse County, which as I understand it is for possession of, you guessed it, a controlled substance. I realize that's not terribly realistic in light of the guideline, in light of the gravity of the offense, in light of the, can we explain to you in a way that makes any sense or would satisfy the curiosity that I would impart to the judge in this matter with regard to why is this person associating with the persons that she's associating with, and why is she in possession of ammunition of all things? The problem is the logic of any story that I could tell you would be clouded behind a haze of consumed methamphetamine. And that is the root of everything that has come to pass probably in Brooke's life for the last, 3 years? She's had some tragedy, as everybody does, and I don't mean to downplay the impact of that tragedy on her, but it does not fill in that blank sufficiently. The only thing it does is that she lives with addiction. And I say that not lightly, because some people don't live with addiction, they die with addiction or from addiction. So at the very minimum, she's still alive, she's still with us. I don't know ultimately what the court ought to do here. I do believe she's in desperate need of treatment, further treatment, sober living, whatever it takes. She needs to build an entire support structure around her, because as of right now, she doesn't have one. And again, that lack of stability in her life is directly responsible for her returning to the only thing that she's really ever depended on, which is methamphetamine. I don't say this to impart pity on her. I don't think she's in need of our pity. I don't think that's a terrible consequence or use to her anyway. I say that because I want to emphasize to the court that she not only needs treatment, she's willing to get it. She's willing to take it. She wants to make a change in her life. She told me just today, of course, I could have looked it up before, I just didn't, because she's 46 years old. I don't think she looks 46. I assume she was much younger than that. But that's neither here nor there. We don't talk about women's ages, I understand.
I was wondering, what the heck are you doing?
Yeah, where am I
You don't do
going
that.
with that? I just wanted to illustrate that she's still got plenty of time. She's still got plenty of energy to fight the fight that she's gonna need to fight. And that is with regard to the demon of addiction. Thank you.
All right, thank you, Mr. Carnes.
Thank you, Your Honor. I don't think that defendant is a good candidate for probation. While she was on bond for this case, she was arrested.
Yeah, for the other case. I know.
For the other case in Grand Traverse, and then if you'll recall, Grand Traverse jail let her out of jail while there were bench warrants pending. Not her fault. I don't blame her at all for that.
No.
But when she was picked up here by Cadillac City Police, she had a pipe on her with white residue that they immediately sent to the MSP lab. So I didn't bring that up as a violation because I don't have enough evidence now. But it is concerning, and by a preponderance of the evidence, I'm guessing it had meth residue in it. Also, the defendant does have a history of retail fraud, which is concerning, although clearly she's not here for that today, but there was an incident of that around the same time as this. So the fact that she's possessing ammunition is extremely concerning. I'd ask the court to sentence the defendant to 18 months in prison.
So she's not only got her drug use, but she also has her methy crimes of retail fraud, which are because of her drug use. So it seems like the best solution is for her to stop using drugs. And I get it. It's an addiction. But she has to put some effort towards that goal. She doesn't seem to want to.
A little towards the higher end of the middle, but it's still in the middle of the guidelines. Thank you.
All right, Ms. Halliday, anything you wish to say at this time, ma'am?
I don't know. Thank you.
All right. I'll note that there are a few dismissals in the defendant's prior criminal history, so obviously I don't count those. But she does have extensive bond violations, probation violations, and parole violations. Every effort of reducing charges from possession of meth down to use of meth, that hasn't helped. And I'm a bit, I think the right word is bothered. If it's not the right word, I apologize. And maybe there's a reason for it. I'm not asking for anybody to explain it to me. So there's a plea. The defendant violates parole back in last year, July 1st, with possession of meth as a second sub or habitual offender fourth. And that got reduced down to a single use. Well, why am I concerned about that? Well, then there was also, back on July 2025, there was a retail fraud. All right, not a big deal, but she was continuing to commit crime on parole. Then on August 15th of 2025, which is the case here, yeah, it was a felon possession of ammunition. There wasn't any felon and possession of a firearm.
It wasn't.
Right, and I don't understand if, and by the way, there's another case, the one that occurred while on bond, that occurred up in Grand Traverse County. They went from possession of meth and possession of cocaine as a HAB-4, and then they gave her 69 days in jail. Now that's because the possession of the cocaine or narcotic is a Class G offense versus a Class D for methamphetamine. And my point is, for using the word bothered, is here's a defendant with an extensive substance use problem or challenge. She keeps making the same bad choices over and over. But when it comes to the drugs, everybody turns their head. She gets a 69-day jail sentence in Grand Traverse County. And this court, in this county, gives her a use. So when I look at possessing a handful of ammunition with no firearm, unless she was going to throw it at somebody really, really fast, it seems like everybody should be focusing on the methamphetamine and the drugs. But now to come to the court and say, well, for possession of 9mm round, and it was in a Ziploc baggie. I don't know. Clearly she's up to no good. Clearly she keeps making bad choices. Clearly she's still struggling with drugs. But all the other courts and the prosecutors who were saying, oh my gosh, drugs are the problem, whoo, we're going to reduce the charges to nothing. I don't know why I would give you prison. The government thought that prison was necessary. I would have thought they would have pushed the methamphetamine and drug cases. But instead, they went after you for having a couple rounds of ammunition. So I have to consider the offense too. Now, if this charge for which you were convicted in this court, if this had been a possession of meth charge, oh, no doubt, I'd send you to prison. Most likely. You can't stay out of trouble. You keep making all the wrong, bad decisions. At your age now, we're unlike the last case where the young person had no, childhood, nobody to help them. You're mid-40s. And you can't figure it out. I don't know what else we can do for you. But Grand Traverse County, they think they've got it right with 36 months of probation. So we're going to let Grand Traverse County on that drug case, since this is you're got a problem with drug addiction, and we're going to let Grand Traverse County deal with it. So this court sentences the defendant as follows. Court sentence will be within the guidelines. The court finds, based upon all the factors I've already described, that the sentence I'm about to announce is reasonable proportion. The bond violations, probation violations, parole violations, repetitive drug history, it just keeps on continuing. You want to continue to use drugs, some people would say, okay.
She's the gift that keeps on giving. Oh no, that's the taxpayers.
But I don't. But again, I'm here today for a handful of 9mm rounds with no firearm. The court sentences the defendant to a jail sentence. While it's 90 days, the court considers that you've been in, when you had another sentence that you were serving at the same time. I'm going, and it's easy for me to set it at 9 months. I'm going to give it somewhere credit. So now I'm going down to 180 days with 62 days of credit. Court assesses a $68 state minimum fee, $130 crime victims' rights fund fee, a $300 court cost, a $500 fine, a $300 attorney fee, no DNA fee, no supervision. We're going to let the county that actually did the drug case deal with supervision. That's the sentence of the court. Miss anything, Mr. Bennett? Mr. Carnes? All right, Mr. Harris is going to bring you 2 copies of one document. You're going to place your initials on one and take the other one with you. Now, place your initials neither elects nor waives any rights. It merely acknowledges your receipt and your copy of the document. This document tells you that you have the right to appeal the conviction and sentence in your case. While that is typically done by filing a claim of right to appeal, any appeal must be done by filing an application for leave to appeal. Not a claim to appeal, but right now, if you choose to file an application for leave to appeal and you want the court to consider appointing an attorney to assist you, may complete the bottom half of the document and return to this court within 42 days. Not appeal, you may simply dispose of your copy of that document.
That's pretty bad. This judge will go out of his way. He will bend over backwards to help people. I've seen him do it. He's one of the most compassionate judges that Michigan has. And he's like, it's not worth even trying with you. You know what? Another county already has you. They can keep you. I'm not going to let you be my county's problem. That's pretty freaking bad. At what point of living your life do you realize, wow, even the judge gave up on me?
This holiday, I really hope you decide to start making better choices, hang out with better people, get rehab. But we're going to let Grand Traverse County provide all that. Thank you. We're adjourned. Our next case is people of the state of Michigan versus Zachary Oswald. This is going to be case number 26-14220 FH. You may, sir. Thank you. As we, I'm going to take appearances, please.
Nick Carnes on behalf of the people. Robert Hertz for Mr. Oswald. I am filling in for the events of the day.
All right, thank you very much. Mr. Oswald is coming in from the jail. He's currently in pretrial custody. As we begin, I'm just going to note here that I received last week and reviewed several reports. First, there was a mitigation report that was filed by Ms. Viravento. That was back on June 2nd. I reviewed that on June 4th. Mr. Oswald is now here in court. One moment. Just want to review my notes. Yep, all right, I recall. That was actually, sorry, I didn't mean to use the word actually. One of the better reports that I've read from the Public Defender's Office on behalf of the client. Sentencing. Attached to that were some other letters that I've also received. There's a letter, a handwritten letter from Ms. Bovey. read that one. There's also a letter from an individual named Tony, or hopefully I said it right. Sometimes people pronounce it Tony Oswald. Thank you. Also from Aunt Kathy. Thank you. Right here today. And of course, a couple of these describe his childhood and adoption and things like that. And this last letter from an individual. All right, that again, I read those all on last Thursday when I read the report from the Public Defender's Office. If I didn't already cover it, Mr. Stephen Saladay, the agent from the Department of Corrections, who prepared today's pre-sentence investigation report, is also here before the court. So we're here today for sentencing in this case. There was a no contest plea entered and accepted by the court on April 20th of this year. All right, so Mr. Carnes, first of all, do we have any corrections to the PSI?
One minor one, Your Honor, on CFJ 284, page 1. The third sentence, he was originally charged with the last part of that says and home invasion, 2nd degree. That was not an original charge, so I would just strike
okay.
that and then put the and before the council.
Copy that. We'll go ahead and make that change. All right, anything else, sir?
No, Your Honor, you do have the victim here and she would like to speak.
All right, we'll get right there in just a moment. Mr. Hartel, any amendments, corrections, or objections to make to the contents?
Partially, Your Honor. Did the court also receive the sentencing memorandum that Ms. Piavento sent to the court?
Oh, I'm sorry, that's what I was referencing.
Oh, okay.
I'm sorry,
With
yes.
mitigation report and the sentencing memorandum.
Yeah, I'm sorry. They were stapled together in the pack that I had. Copy that. Thank you.
She has asked me to object to offense variable 10 for the scoring of 5 points on counts 2 and 3, Your Honor.
Yep. All right. Let's take a look here. Offense variable number 10 is scored for exploitation of vulnerable victims. And let's take a look here. And I'm just reviewing, and I'm not surprised by this because I'm just reviewing what Ms. Piavento presented within her report. I just didn't cover it earlier because it's more about scoring and not regarding the allocution stuff and personal information about the defendant. All right, so I'm going to allow you to go ahead and continue to make the argument. And I do see that she has talked about that inside of her report, which is also received back on June 2nd in my office. And she covers that beginning on page 1, continuing through at least page 3. All right, sir, go ahead.
Thank you, Your Honor. I know I'm oversimplifying it a bit because I don't doubt she worded it more eloquently in her memorandum, and I asked the court to factor that in as well. But one of the main things that we're asking the court to factor in is that for offense variable 10, we believe that it involves, it requires the exploitation and manipulation of the victim for selfish and unethical purposes. My client had no clue what was going on. We don't believe he had the mens rea to be selfish or manipulative. We believe that although he regrets everything, and that might be more for the sentencing portion of it,
sure,
because there was no intent involved. There couldn't be the intent to manipulate or be selfish. And although I am oversimplifying her memorandum, I do ask the court to still factor in the way
Sure.
she wrote it. That's the way I interpret it. Thank you.
All right, let's take a look here. I note on CFJ 284, page 1, Mr. Saladay did reference it, but based upon size of the defendant and strength compared to the others. Let's take a look here at the defense description that begins on page 2 of that same section. One moment. Mr. Carnes?
Thank you, Your Honor. I think the present case does involve exploitation. The defense cites a number of cases like driving drunk with a child in the car. I can see that being grossly irresponsible. Here, the defendant clearly was stronger. As we read through the description, there's 2 victims. He's fighting with both of them at the same time, overpowering both of them at the same time. And this is not just irresponsible behavior. voluntary intoxication is not a defense here, and he's overpowering them with his strength. So I think OB 10 is probably scored at 5 points.
Let's talk about how he entered the residence. Why was it that he entered the residence, at least based upon the description and the facts of the case? Did he know which residence he was entering? Did he think it was a different entrance, or I'm sorry, different residence?
It's my understanding he didn't know which residence he was entering.
Okay. All right.
But I would look past that and towards the actual assault, and in that case, he was superior strength.
Maybe what I'll do is, since you're going to have a victim impact statement, I think it's probably incumbent upon me to wait till I hear from the victim impact statement. That individual may have more information to provide that would answer that question. All right, thank you. So I know there was a discussion here regarding the scoring of offense variable 10. Any other challenges? No, I think so.
Nothing else.
All right, thank you very much. So at this time, but again, I suspected that from the information contained here, you may present your victim impact statement, sir.
Yes, sure. She's here to make the statement.
All right, thank you very much. Yes, please state for us your first and your last name.
Julian Frosty.
All right, thank you. Ms. Frosty? What does he like to say?
I believe that he knew everything of what he was doing.
All right, and why do you say that?
Because the duration of him choking life out of me was almost 2 hours. In front of my children, I'm a single mom with 6 kids in the house. I announced numerous times this was not his house. And I have children in the house. And he just kept saying, I'm gonna kill you. I don't care how long I get, I'm gonna come back and kill you and your family. I had no idea who this guy was. It was still wintertime. This guy walked in with no shirt, no shoes on, just a pair of pants.
You might have had, do you have socks on? But anyways, I recall, I read it. Don't worry about it.
If I remember right, he had socks on.
It's all right, I know. Keep going.
This happened in front of all my children. I fought for my life. He almost strangled me to death multiple times. Hitting my head off everything. I had numerous blows on my head. I tried to fight as much as I could, because I would die for my kids.
How old are your children that were home? I don't need to
My
know
youngest is 10 years old. My oldest is 20.
And were there just 2 or there more?
6.
6, okay.
I had them all hiding upstairs. Besides my 17-year-old, she was forced to watch everything right in front of her. After everything I dealt with last year, taking the protector that was in our house.
For the record, I recall the case. I know which one you're talking about. Thank you.
I didn't deserve this. I didn't ask for this. He should get everything that he has coming to him. Because I still can't sleep at night. Because I worry about who might be around my house. I just hope he gets the help that he needs. And I hope he doesn't do this to any other person.
Thank you, Ms. Foxy. Appreciate it. Thank you. Pursuant to People versus Cannon 481 Mich 152, a Michigan Supreme Court decision from 2008. There are a list of several factors that the court is allowed to consider. Now, those factors are not all encompassing, but they do talk about size of the offender versus that of the victim. But it also talks about predatory conduct or exploitation of those circumstances. In this particular instance, this went on. If this had been an incident where the defendant walked in, had become assaulted with somebody, confused, didn't know where he was at, but then continues, it's different. It's not like it lasted 5 minutes or 10 minutes. This continued for hours. And he exploited the fact that she had multiple people there in the home. Now, there was no domestic relationship. I know that's not it. It's not like he was abusing a domestic relationship or power and authority over Miss Frosty and her children. But the fact is he was exploiting the situation with the children there, with her being there, with not 5 minutes, not 10 minutes, not 15, 30, not 60, not 9, 2 hours of this going on. So is that, does it show some predatory type conduct? Yes. And does it show that he's manipulating this situation? Yeah. And was he abusing this, his size and strength over that of Miss Frosty? Yeah. So, one moment. And here, this is the language I was looking for. I remember it, but I could not place it, but I found it. People versus Houston, another Michigan Supreme Court case, 489 Mich at 451. This one in 2011. And it might be, instead of a defendant's, quote, predatory conduct, end quote, by the conduct alone can create and enhance a victim's vulnerability. And that's why I went straight to the fact that he was enhancing her vulnerability by the fact that the children were there. And if a person like Miss Frosty, a mother of multiple children of a variety of ages in that home, he's manipulating that situation and did by using that and helping, that helped to control her. So this was, whether it's predatory conduct, which I do think it was also where he used the size and authority and their circumstances, enhancing the victim's vulnerability because of the potential danger to the children. Therefore, the court denies the challenge for offense variable 10 for those factors. Mr. Hartel, oh wait, I'm sorry, Mr. Carnes, allocution, sir.
Thank you, Your Honor. I must say, I did think that this mitigation report supplied by the defender's office was very well written, well thought out. I was impressed by it too.
And I appreciated the effort. And they have a good staff down there, and as far as their social workers, I agree. I understand.
Unsurprisingly, and to no fault of their own, it's one-sided. I mean, that's the nature of this game. And I just asked the court, I'm sorry, game is the inappropriate word. It's the nature of what we do. I asked the court to also take into account Ms. Frosty's statements and Ms. Nolan's statements, which are contained in the PSI. This was absolutely terrifying to have somebody come into your home that's filled with young children and assault the victims for this length of time. I would ask the court to sentence in the middle of the guidelines, which I did some math on count 2, which would be 52 months, and then 38 months on count 1. I do think that takes into account everything brought up in the mitigation report while still recognizing this absolutely horrific incident.
Here's the thing. At that point, I mean, he's not there to rob them. He's not there to take anything. He's not there to settle a score. The only thing that he's there for is to terrorize them and make them a victim. And he's getting nothing but entertainment and joy out of doing so. I don't care what he was impaired on. If he was impaired on anything. I don't care if he was going through a mental health crisis and just happened to snap. I don't care. That kind of behavior cannot be tolerated under any circumstances. He needs a punishment that includes a very lengthy incarceration period. And I know they'll never see a lick of restitution, but I think the judge needs to impose an order that he's responsible for the children's therapy. And the judge should order that all of the victims go into mental health services to deal with the trauma that this lowlife scum caused them. 2 hours of being held hostage in your home and choked repeatedly, only for them to let you live just to do it again. Nah.
Miss Frosty's, Miss Nolan's, and Miss Frosty's children's lives. It's completely terrifying. I can't imagine what they went through. I also hope this is a wake-up call for the defendant that he really should never drink again. If this was just a drunken mistake, it's a drunken mistake. I can imagine that doesn't involve another.
Mr. Hartel?
Yes, thank you, Your Honor. In addition to what is in the mitigation report, I have regrouped with Ms. Viovento and my clients. And just so the court is aware, he has been trying to better himself while in the jail. He does want to get the help that he knows he needs. I do have certificates if the court wants to see them from.
Sure.
I don't know if the people are getting approaching Catholic Human Services as well as if I may approach you.
Yeah, you may. Thank you very much, Mr. Hartel. The court will consider those. You may continue.
Part of what I'm trying to get at, Your Honor, is I know this was a no contest, and if, especially if it was civil liability, I wouldn't be saying how sympathetic he is, but he is. He doesn't remember the incident. He knows it's because of things he needs to fix, but he regrets that it happened. He doesn't want this to ever happen again. He wishes it had never happened, not because of what's happening to him, but what happened to them. He doesn't want to see this happen to anyone ever, to be frank, and it shouldn't. We know that. But he does want to better himself. He has applied to Toski Hall. He doesn't have an exact set date, but regardless of what the court sentences him to, and we would ask the court to sentence him as low as possible, obviously. But if there could be a way to fashion the sentence so he could still go to that treatment, we would highly appreciate that. We expect a bed date any day now. And I don't believe my client should make a statement, but I put a statement. No, okay. But we would just point out that he does have some of the family that wrote those letters in the court for support whenever he does get out. We know this isn't going to be a life sentence. We know that family is going to continue to provide that support, make sure that he continues to have the love that he needs to encourage him to do the things that he needs to do. I haven't spoken to them directly, but based on what I've read in those letters, I know that they feel the same way that I know he feels. Thank you.
All right. Because you spoke for your client, and I know there's no contest, and I did see him shake his head that he did not wish to speak. So I respect that, and I appreciate that there's a no contest plea. In these situations, there's nothing the judge is going to say that's going to make both sides feel any better. There's no big grand impact where you walk out of here and go, ah, that's done, or ah, I feel healed for the victim or the defendant's family. Nothing I can say. In fact, it's going to be very anticlimactic. It always is. Nothing can undo or fix necessarily what happened in situations of this sort. So to those that are here on both sides of the aisle, thank you for being here. Ms. Frosty, I really needed to hear your testimony. And I'm going to comment about that in just a moment. For the family, when I read each one of the names, I saw a head bob, so I know who those people are, and I thank you. Thank them and want you to realize you've got a good source of support in your life. And keep using them, turn to them, because you're going to need them every day. So there's something in the legal world we call the eggshell plaintiff. Now, that's typically in a civil suit. You know, for instance, if you were to punch somebody and they've got a really thick head like our bailiff, Deputy Longstreet, not much is gonna happen. But you go over here and punch Nancy in front of me, and she's got the skull of an eggshell. And it costs $1 million to fix hers. His, it's 50 cents. But still, you're responsible for it. Now, I'm not going to discuss it, Ms. Frosty, but I know the case, and I think the council here do. You picked the wrong house. What they had gone through in the past, and they had a case here a year ago, was horrific. And the impact of this, and I know whether or not you do or don't recall everything, I'm going to tell you, is deeper than you know. And out of respect for the family, I'm not going to go into it. But you picked the wrong household. They've been through hell. And you had to do it. What you did was wrong no matter what. But you picked, and I'm not trying to be rude and call them an eggshell and say that they're fragile, because I think people can overcome. And I know people have strength and find strength in places they didn't even know existed. You picked the eggshell. You got love and support, and that's great. And I want you to continue to look to them, rely upon them. Whatever led you to this phase has got to not happen again. And I'm going to trust that you're going to hear these words, and that you're going to hear those words, and hear that love, hear that support, hear those compliments. First of all, alcohol and marijuana are not going to help you. And you're illegally drinking alcohol, and you've been illegally doing weed for the last couple of years. Well, stop it. Almost every young person that comes in here, somebody under 25, and remember, I do the felony cases. I always look on this one page, CFJ 145, page 1, and I see exactly what I see. Alcohol, marijuana, starting at the age where it's illegal. So stop it. Not helping. Okay. Now, you don't have any prior criminal history. I would expect that from somebody of your age. But you started off with a big bang. And you have scored intermediate, presumptive prison cells. And this will be a prison sentence. And I want you to pay attention. When you're there, I want you to pick the right program. I want you to find a way to learn, educate. You can get a college degree from this. Now, it may not seem like it's a great idea, but it is. You get skilled trades that are there. You get counseling, whatever may have caused you to be in this position. I know that I'm going to assume right now behind those glasses, and that's, you look like Buddy Holly. Anyways, if you don't know who Buddy Holly is, you don't. Gosh darn it, I'm aging myself. Well, anyways, you're going to come out. You're going to put this behind you. You're still going to be an extremely young man, and you're going to be able to learn from this. And you're not only going to be able to fix your life, but when you fix your life, you help those that are around you because they care about you. And I can tell that the people behind you carry the weight of this on them too. So, and what I'm going to sentence here isn't going to make anybody feel better. It's not going to make Miss Frosty feel a whole lot better, or her children feel safer, and it's not going to make your family feel better. But I find that the sentence is going to be fair and reasonable. And I did, by the way, for the record, I need to state, I did look at the treatment program sheet as well as the two certificates of Catholic Human Services. And we go through a lot to help provide Catholic Human Services in our jail. The state of Michigan doesn't help us. We do it locally. All right. So the sentence of the court follows: 2 $68 state minimum fees, 1 $50 state minimum fee for the misdemeanor, a $130 crime victims right fund fee. I will not assess any other cost or fines or supervision fees, obviously, because I'm not going to give any period of probation. The court will, for count one, and these will all run concurrently with one another. The court on count one sentences the defendant to, I'm just going to give him 106 days with 106 days of credit. That clears off the misdemeanor on the file. But as for count two, which is the assault with intent to do great bodily harm, which includes the strangulation, the court sentences the defendant to a prison term, and it's within the guideline range that is listed here on CFJ 145. I'm sorry, IR 88. And I'm going to note that it's still within the guideline range of, even if I took off those points for the DOB 10. So there I find it to be a fair, reasonable, and I don't think that even if you look at my ruling, that it's going to result in any unfair prejudice to the defendant, and it's not any shock at all. For that count, the court sentences the defendant to a prison term of 24 months to 120 months with 106 days of credit. That is actually toward the lower end of that guideline range. The lowest was 19 months. I added 6 months above that. The maximum could have been up to 36 months. Now, as to as to the second felony count, which is listed as count 3. Here we already know the maximum is 180 months with 106 days of credit. But as for the bottom end, the court sentences the defendant here to a prison term of, at the bottom, of 36 months. Again, I'm considering the defendant's age, youthfulness. He doesn't have any priors. My sentence is right in the middle of the guidelines. I know nobody is going to both people can walk out of here thinking, well, I wish the judge would have done more or less. But my sentences are within the guideline ranges. And 3 years to somebody who is 19 is a bigger portion of their life. Me, I think of stuff I did 3 years ago, and I thought it happened a week ago, or maybe a month. I'm always surprised. And I almost, when I look over that side of the courtroom, I feel like I should be increasing. But I want you to know, you picked the eggshell. You have no idea. But I've seen that family, and I think they've got some strength, and I'm going to hope that they find some strength here. Every morning that you're there, when you wake up and you swing your feet over, put them on the floor, I want you to think about what you did and how you can help. Not just you, because this is not that much about you. Look, it's about a third you. A lot them and a lot your family. Have I missed anything, Mr. Saladay? Mr. Carnes?
$60 DNA fee.
$60, I'm sorry, $60 DNA fee, and that's payable to the Washburn County Sheriff Department. All right, Mr. Hartel is going to bring to you, sir, 2 copies of one document. You're going to place your initials on one. Doing so neither elects nor waives any rights. It merely acknowledges your receipt of your copy of that document. Now, this document tells you that you have the right to appeal the conviction and sentence in your case. And that is typically done by filing a claim of right to appeal. However, based upon the plea in this case, any appeal must be done by filing an application for leave to appeal. Now, if you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of the document and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of that document. All fines and costs are doable or payable within 56 days. Failure to do so can result in a penalty of 20% being added. The court, since we're really talking barely $200 some odd, the court will make those fines and costs collectible before you can be released on parole. It's a relatively small amount. So, all right. Anything else, Mr. Hartel?
No, Your Honor. Would the court like to keep those copies of the AA?
No, you should take those with you. If you need to keep them for the file for any other reason, somebody else will. That way you have them available. Yeah, you may. Thank you. Now, again, the defendant does have the right to appeal. However, I find that my sentence is reasonable, proportional, based upon the factors discussed today on the record. And I also recognize that each sentence is within the guidelines and at the lower end of the guidelines. again, all the offenses run concurrent with one another. Thank you very much. We are adjourned. Our next file is People of the State of Michigan versus Jason Luca. File number is 25-14059-FH.
I think this is the one that the case itself isn't that interesting, but the judge's banter is something that I thought Jerry would absolutely love. So I kind of put this one in there, just left it in for Jerry. And I think it's the last one.
May I approach her?
You couldn't miss one. I was mostly trying to speak. All right. Oh, wait, we got Miss Williams coming up. And the speaker's coming, and do we have Mr. Luca? Oh, take your time. I got you. Thank you for being patient. All right. Appearances from counsel, beginning with the Assistant Attorney General.
Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
And James Dick on behalf of Mr. Luca, Your Honor, who is appearing in the courtroom.
Mr. Luke is here in court. Mr. Stephen Saladay is here as the agent from the Department of Corrections. Ms. Williams, you look like you were in some kind of space pod. Are you okay?
I'm good. I'm actually at home. I don't know what that means, but
I don't know, but it looks like, look, it's red in the background. It reminds me of Space Odyssey. All right, thank you. All right, so we're here today for a delay of sentence update. The court has before it the original PSI as well as the CFJ 104. Let me take a look here. Ms. Williams, any objection to the court continuing this update here or its content?
no, Your Honor.
And Mr. Dixon, question?
None, Your Honor.
All right, I can't remember. Did he pay his arrears down to the 8,700?
Your Honor.
Nearly. I'm sorry. My apologies.
Go ahead.
Last time I checked, he was at 34 cents. I'm pretty sure I'll come up with the other $180 before this delay ends here.
Before, when's the delay? When's the total year over with?
7/13, July 13th.
Ms. Williams, I've got two options for you. Number one, I can delay the sentence until after that date ends. Or I can sentence the delay and you today, and you can say, well, he didn't complete it. The court believes that based upon not only statute, but also case law, it still retains jurisdiction as long as I have the matter set for a hearing prior to the end of that date. I mean, I don't have to have the hearing that date. So what would you like me to do, Ms. Williams? Adjourn it to make sure he pays the other, whatever it was, somebody else can do the math, $1,100? What's that?
$188.
$188. What would you like me to do today?
Yes, Your Honor. We would, the defense counsel and I discussed that, and we would like for you to extend the delay. We also, but we had, I think he had an additional information, an additional request.
All right, go ahead, Mr. Dick.
Your Honor, so Mr. Luca, he was in a rather major car accident in January. He is currently beginning therapy and everything due to that accident. He did make diligent efforts to pay down as much as he could, including, yes, and with that, Your Honor, we do believe within the next 6 to 12 months that he will be able to pay the entire amount in full. I have discussed with him potentially waiving the jurisdictional limitations if the court would be willing to extend this matter, the essentially the delay period. I did also discuss it with Ms. Williams, and I do not believe she has any objection to the court doing that if the court would be willing to do so.
Ms. Williams, oh, sorry, go ahead. Ms. Williams, let me analyze this. I don't think I can waive a jurisdictional issue. And I'm afraid of creating that precedent. I'd rather set it for, the next hearing, and that'll give them another month to pay. And then when we come back here, let's just take another look at it at that time. I don't think I can waive that jurisdictional delay. Now, if somebody wants to do a little research, that's great. What I'm always afraid of is those decisions that some judges may do. And by the way, I've been a defense attorney a good portion, and Mr. Dick, I would get that done a lot of times in other counties, but I'm not that guy. I don't think I can waive a jurisdictional delay. I don't think I have the authority unless somebody tells me that there's some case law out there that says that I do, but I don't think they're gonna find it because the jurisdictional authority ends when that happens by law. So now if the parties wish to come up with some other magical thing, that's fine by me. I don't know. So, all right, so here's what we're gonna do. We'll leave it to Mr. Dick and Miss Williams. And I now turn to Lucia, I'm sorry, sir. Mr. Lucia, we're gonna have another date set. It should be in about a month, maybe 6 weeks between now and by the time we get here. And we'll see how long it takes. And I'm gonna put on here because I believe and interpret the case law to say I don't lose jurisdiction as long as I set the hearing within 12 months. I'm going to tell my staff to set the hearing done within, I'm going to say 60 days. Does that sound all right, Ms. Williams and Mr. Dick? It kind of is almost in the middle. And as long as my staff issues a notice for sentencing prior to the end of that year, I think we're okay. That's how I'm doing it. All right, sounds great. That's what we're gonna do. Mr. Lucia, I did see you win some pain, so I'm very sorry to hear about the accident. Hopefully you're doing better. Hopefully you're getting good medical care. All right? All right, bond here, but I'm sorry, you still continue. Ms. Williams, I'm just gonna do this because I can, because again, I said it reminds me of the Space Odyssey. I don't know if you've all seen the movie, but that's when he's talking to Hal, the computer, and he says, I can't do that, Dave. Anyway, sorry. Never mind. Go watch the movie. Thank you. We're adjourned.
Thank you. Have a good day.
You got it.
I can't do that, Dave.
Have a good day. I can't do that, Dave. You know he was waiting. He spent that whole hearing. If she says have a good day, I'm going to say it. I'm going to say it. I know. I love that. and we all know Jerry is the movie buff guy. He loves the movies and he plays them every Saturday in the Discord. So I had to include that. Oh. So Charlie has sent some information. I'm going to put it in the Discord, but it's regarding, actually, he texted me some information and I'll put it in I can do it. Anyways, I'm going to put it in the Discord. It involves information regarding what that family went through. So, and then y'all do whatever you're going to do. Rabbit holes, whatever. Thank you so much, Charlie. I know everybody was nosy about it. I was nosy about it, but I just didn't have time to look it up. All right. I'm going to take off. Thank you guys so much. Be safe Be well, sleep sweet, and much love.